Tim, one question members frequently ask is why should we set up a partnership?
Well, it's a very good question. I mean, it can sound daunting. It sounds like you're getting into a legal relationship, and that's sort of anathema where you think you're good friends, you trust each other,
Mm.
everything's cozy. The simple fact is, by being in a group, by working together for a common goal with a view to profit, which generally you are in a partnership, whether you know it, whether you want it to be, or not. The legal relationships between people who are in a business, a common business for profit, means that under Section 1 of the Partnership Act, you are a partnership
Mm.
and your activities are governed by the Partnership Act, which is all well and good. It does provide a framework as to how your activities are governed and how your relationships are governed, but it is an act from 135 years ago. It isn't designed for the needs and experiences of musicians. It's designed to cover every kind of business. And so you'll find that aspects of it may be suitable for what you're trying to achieve and how you want to govern your relationship, but others may not be. In particular, it deems that you're all equal partners. Therefore, any property bought into the partnership or purchased by the partnership is shared equally between you. That sounds all very well and good. But if people are contributing money in different proportions, or uh, certain members of the group require more financial input for buying their equipment, guitars as opposed to keyboards or whatever, it it would mean that everyone owns everything equally, whereas it may not actually reflect the reality of who owns what within the group. So that's quite important. It also means that all decisions are taken um, in a unanimous manner. So that may suit what you want to do, but also it may be that certain decisions of the group that you feel should be taken by majority. The more simple decisions that have to be reached, a touring schedule or repertoire or so forth, as opposed to signing a record agreement or a publishing contract, engaging a manager. Um, so you can, by having your own tailor-made, bespoke written agreement, you can stipulate how decisions are to be taken in relation to different types of question. So that gives you more power over how the way the partnership works. Also, if things do go wrong, the Partnership Act says that it has to be a unanimous decision to expel a partner. That includes the person to be expelled, and now it's most unlikely that that partner is going to agree to be expelled. So you're automatically getting into a sort of deadlock, which can only be solved by terminating the partnership. Now, that of itself is a problem, because if the partnership is terminated, it can't be a question of simply the majority of members carrying on under the name with the same equipment, because the termination of the partnership means that the partnership assets have to be dissolved and liquidated. And so nobody can use the assets without the consent of everybody. This, as I'm sure you'll understand, presents a lot of problems to the band continuing in an effective manner. If you have a written partnership agreement, you can dictate what happens if you want to expel a partner, how that decision is taken, and what happens to the assets of the group, the equipment, the name, goodwill, websites, so forth, and how the exiting member is compensated for their share of the assets up until that point, that they can get their own equipment back, equipment that they've bought themselves, and how much, for instance, they're going to receive for their share of the value of the other assets that their endeavours have helped pay for, but they're leaving behind in the group. So it gives you much more control over that. Again, if a member unfortunately passes away, that under the Partnership Act acts to dissolve the partnership. Whereas you can stipulate under a partnership agreement that that isn't the case, that the remaining members can continue the group, and obviously provision can be made for the estate of the deceased member. But these are the sort of things where practical life comes into comes to bear upon the activities of the group, and it's not always best suited by the terms of the Partnership Act, whereas your own partnership agreement sitting alongside that can help you decide what you want to do in any particular circumstance.
So really, you are already in a partnership. Even if you haven't got a partnership agreement, you're just governed by a set of very old laws that aren't tailored towards musicians.
Absolutely.
So you may as well decide yourselves what those rules are
Yeah,
by entering into an agreement.
this is it. And you're not doing anything strange or in any way unusual by doing that. The partnership agreement, the Partnership Act does say that these rules apply unless you agree something else.
Yeah.
So it's the Partnership Act absolutely anticipates that people will agree their own rules to work alongside or totally replace the provisions of the Partnership Act. So, as we said earlier, you're in a partnership really whether you like it or not. So why not make it your partnership and one that works for you, that has the rules and guidelines that you want to set in place and is tailored to deal with the way you want to share the income between you, share physical property such as equipment, share intellectual property rights such as the rights in recordings and the rights in the publishing. So, it just is allowing you to set the rules for the game rather than have them dictated to you.
Yep. Thanks, Tim.